Sorry, everybody, I got kicked off of my Zoom and had to reset the password, so it'll get locked up. All right, are you Austin Reed Leitner, there to jail? All right. It's case number 21 CR 54, State of Ohio versus Austin Reed Leitner. This hearing is being conducted by Zoom due to COVID-19 issues in the county and the jails and everywhere else. Mr. Leitner's attorney is Danielle Witt, appearing from her office, appearing from his office is Assistant Prosecutor King, also represents the probation department. The defendant has entered plea of guilty to grand theft of firearms and third-degree felony. The matter was set for hearing, I think, originally on the 1st, and then it was continued until today. The court did order a pre-sentence investigation. I have reviewed that, and have the attorneys had an opportunity to review the pre-sentence summary.
State, Your Honor.
Yes, Your Honor.
All right, Mr. King, on behalf of the state.
Only was contained in the plea agreement, Your Honor.
All right, Ms. Witt, on behalf of the defendants.
Yes, Your Honor. We ask the court to follow the joint recommendation of the plea agreement for Austin to receive community control. This is his first felony, and alcohol and drugs has been a significant part of Austin's life since he was 13 years old and continues to be so, and is the root of the criminal actions in this charge. So, and it is also my understanding that there is a bed available for Austin at the Massey House on October 4th, so we just ask for community control and to allow him the chance for this inpatient facility.
All right, I do have that letter, October 4th is that date. All right, Mr. Leitner, anything you would like to say?
No, Your Honor. I believe you have the best interest.
All right, what are you in jail for right now? I understand you're in jail for something out of municipal court?
Yes, sir. McKenna didn't like the fact that I didn't have everything paid off, which I completely understand because I should have by now.
So you're on a probation violation? Is that what you're in for, a probation violation?
I guess so.
All right, have you got a definite sentence or what's going on?
I was supposed to do 10 days, but I already served 2 of it back in February because I was clean.
All right, so I just wondered if there's going to be a problem with that day. All right. All right, the court ordered that you be sentenced to a term of 3 years of community control supervision under the control of the supervision of the probation department. You'll be required to comply with these conditions, Mr. Leitner. First, you obey all laws, all jurisdictions, conduct yourself in a law-abiding manner on time, report when and as directed, be truthful in all statements you make to the probation department as well as any answers you give them to questions that I ask you. You are to keep them informed of your residence and place of employment all the time. You may not change either without prior permission. You may not leave the state of Ohio at any time without prior written permission. You have to have that written pass with you at all times when you are out of state. It's not permitted to enter upon the grounds of any correctional facility, nor may you communicate with or attempt to communicate with anyone who is an inmate in any of those facilities without prior written permission of your supervising officer. You may not purchase, possess, own, use, or have under your control any firearm, ammunition, dangerous ordnance, weapons of any other type. You may not purchase, possess, use, or have under your control any controlled substance, drug abuse, CBD, oil, kratom, or any grain or analog of a controlled substance that has effects that are similar to that or drugs of abuse. Nor may you have any instrument, device, or thing that may be used to administer them or prepare them for administration unless you have a lawful prescription. You must provide a copy of that within 24 hours of receipt to your probation officer. You may not purchase, possess, use, or have under your control any alcoholic beverage, nor may you be present in places where the soul will be consumed, even otherwise lawful. You are not to associate with anyone who is a co-defendant or any other person who has a criminal record, member of the gang or the criminal group, or any other person who has a past and could in the future influence you to commit a criminal offense or violate these conditions. unless approved in writing by your supervised officer. After Dave is married, order you may not marry or establish cohabitation, common law marriage type relationship with another person without written permission. You must report any contact with law enforcement or arrest, citation, conviction, or other charge of violating the law not later than the next business day after that occurs. You must provide your supervising officer a financial information record so your ability to pay any restitution fees and costs will be reviewed. You're referred by probation for further evaluation or assessment for any other type of treatment, therapy, programming beyond that ordered by the court. You'll submit to that, and if there's a recommendation for a programming, you should enroll in and successfully complete that. You'll be required to pay the court costs of this action and make payment arrangements to do so with the clerk. You'll be required to do 400 hours of community service for 20 hours per week for 20 consecutive weeks unless you're employed at least 20 hours a week, a full-time student, or is documented by a physician prior disability finding you're physically unable to do that. There's no restitution, is there, Mr. King?
That's correct, no restitution.
All right. You'll be required to successfully complete the Massey House program and aftercare, and you'll remain in jail until you are conveyed to the Massey House on October the 4th. Now, by being placed on community control rather than being sentenced to prison, you're deemed to have been sent to a search without a warrant of your person, residence, vehicles owned by you or used by you, or any other property place that's under your control, where you're found at any time by any officer of the probation department. Now, in the event that, it's also ordered to pay the court costs as a substantive order, which means that if you don't make payment arrangements, not only are you in violation of probation, but the clerk could also collect that through various other means, including collecting on bank accounts, wages, earnings, or other assets that you may have. That doesn't collect it, then the court could order you to do service above that already ordered, and give you credit for each hour you work, and an hourly rate set by the court, each hour you work, reduce your judgment by that amount until paid in full. Now, in the event that the probation department feels that you have failed to comply, they will file a written notice of that with the court. You'll be served a copy, you'll be entitled to have a hearing, and be represented by an attorney. The outcome of that hearing is that you have failed to comply, and at that time, the court would revoke community control and then send you to prison for up to anywhere from 9 to 36 months and fine you $10,000. If that happens, once you complete your community control, it is possible that the adult parole authority once you complete your prison term imposed by the court, the adult parole authority may decide that you should be under post-release control supervision for free. Now that is optional, it's not mandatory, but they make the decision, not the court. If they do, you'll be supervised on the terms they set, and if they determine during that period of time that you're being supervised that you have failed to comply, they can return you to prison, make you serve an additional period of up to half of the prison term imposed by the court as max, 9 months for any one violation, but a limit of half of the prison term for all violations. But if you commit a new felony, then in addition to whatever sentence the judge in the new case will impose on you, that judge is also authorized to sentence you in this case to an additional period of 1 year, whatever time left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively to the sentence in the new case. All right, is there anything further from counsel?
No, Your Honor.
Any questions, Mr. Reichner?
Thanks, Bill.
All right, thank you. All right. Now, Mr. Carr, Mr. Wagner was going to sign in, I think, for Mr. Carr.
There's a separate Zoom link for that one, Your Honor.
Oh, there is?
Yeah, so that's where JD's at.
Okay, I'll have to sign off that, we'll have to sign into that one then.
Okay.
Thank you. the jail room. Log in, yes. They're not on there, tell them they have to log back in the new invitation was sent. All right, yeah, Mr. Parr.
Yes, sir.
Todd Parr.
On the record.
All right, you're Todd Lester Parr, appearing on video there for the jail.
Yes, sir.
All right, this is case number 21 CR 0556, State of Ohio versus Todd Lester Parr. This hearing is being conducted by Zoom due to COVID-19 issues at the jail, the sheriff's office, and everywhere else in the county. The defendant's attorney, Jacob Wagner, he's appearing by Zoom, like the courthouse.
Law library.
Oh, library, okay, look familiar. And Mr. King, on behalf of the state, is appearing also from his office. Now, Mr. Wagner, you and your client are both in agreement that this matter can be conducted remotely using Zoom rather than in-person appearance.
That's correct, Your Honor. For the record, I've seen Todd in the past. I just got to see him today because he just got out of quarantine. So he's fresh out. But yes.
Okay. You're okay with that, Mr. Parr?
Yes, sir.
All right, thank you. Now, Mr. Parr, since you're not in the courtroom sitting next to your attorney, as we would typically have you arranged, if you need to speak with Mr. Wagner at any time during this hearing, to ask any questions or talk to him about any concerns, just tell me, and I'll put you and him into a breakout room. It'll be just the two of you on the screen talking. No one else will be able to see or hear you, and you won't be recorded. Okay?
Okay.
All right. Now, the defendant is charged with failure to register a change of address as a registered sex offender, third-degree felony. I think we have had a pre-trial set, I think, this afternoon, that Mr. Wagner agreed to try to do it this morning. Since Mr. Parr was now available, and I don't recall when this matter set for trial, but in any event, Mr. Parr, I've been presented with a plea of guilty form, which says you're going to plead guilty to the charge. Now, this is a 3-page form that the prosecutor's office prepared from their computer, puts in the information about your case. I'm going to hold up the first page, and you see the your name and case number and your name and the plea guilty form there and the charge?
Yes, sir.
All right, and then it's a 3-page document. On page 3, there's a sentence right below a paragraph continuing from the previous page. It says, "I enter this plea voluntarily." Underneath that, there's a line for signature of defendant. Now, I'll hold that up to the screen. And is that your signature there at the top of my index finger?
Yes, sir.
When did you sign this document, Mr. Carr?
When?
Yeah.
Today, I believe.
All right. Now, before you signed it, did Mr. Wagner go over with you and explain it to you and answer any questions you had?
Yes, sir.
And do you feel you had enough time to fully consider this matter before making this decision?
Yes, sir.
You've been talking with him about it throughout the case, even before you were in quarantine?
Yes, sir.
All right. You feel you've been rushed or pressured in any way to doing this?
No, sir.
Are you entering into this agreement to plead guilty voluntarily?
Yes, sir.
All right. The agreement states on page 1 that you're going to withdraw your not guilty plea, plead guilty to the charge of failure to register a change of address as a registered sex offender under 2950.05 F1, a third-degree felony. That's of the high-rise code, a third-degree felony. And it states you understand the maximum penalty for that, if convicted, could be 36 months in prison. The minimum term that could be imposed if prison is imposed is 9 months, and there's certain levels in between those two numbers. There's also a fine available up to $10,000. You understand that?
Yes, sir.
Are you facing any felony charges in any other jurisdiction?
No, sir.
Are you currently on probation, community control, parole, or post-release control for a felony from any other jurisdiction?
Yes, I'm on community control for Franklin County.
Okay, for a felony?
It's felony community control.
Okay. So the reason I ask that is that at some time you should be sentenced to prison on both this charge and the other charge in Franklin County. The sentences could be ordered to be served consecutively, meaning one after the other. You understand that?
Yes, sir.
Now, under the law, Mr. Barr, should you be sentenced to prison, in this case, once you are, you have completed the sentence that's imposed by the court, the adult parole authority may, at their option, place you in what's called post-release control for a period of up to 3 years. They don't have to, but they can, but it's up to them. So what that means is that you would be supervised in the terms of the parole authority set, because the court has no involvement with that, for a period, actually, no, this is not considered a sex offense, all right? So, yeah, it is still optional. And so they would set the conditions and the length of time that they would have under supervision up to 3 years. And if during that period of time they determine that you would fail to comply with those conditions, they could return you to prison, serve an additional period beyond that you already served by the order of this court, for up to 9 months for one violation, up to a maximum of half of your prison term for all violations as a cap. However, if you are convicted of a new felony while under post-release control supervision, then in addition to whatever sentence the judge in new case would impose upon you, that judge could also sentence you for committing that offense while under post-release control. In this case, an additional period of 1 year, whatever time might be left on that period of post-release control, whichever is more, that occurred, then that sentence would have to be served consecutively to the sentence in the new case. Do you understand that?
Yes, sir.
Right now, the court does not require a sentence a person convicted of this offense in prison. I can impose what's called community control or probation, and that means that instead of going to prison, if you put under supervision of the probation department on the term set by the court for a period of up to 3 years, and if during that period of time the probation department felt that you were not in compliance, they would file a written notice of that with the court. You would be entitled to have a hearing, and if the outcome of that hearing was that you had failed to comply, then at that time the court could revoke your community control and then sentence you 36 months and fine you $10,000. Do you understand that?
Yes, sir.
Right now, the charge alleges that beginning on about January 21, 2021, continuing thereafter in Highland County, that you being a registered sex offender convicted out of Union County Common Police Court in case number 2010 CR 0114, and reporting the premise of law after 2008, having a duty to register a change of address, failed to provide any notice of change of address within 20 days by written notice, was reckless in that regard, having previously been convicted of unlawful sexual conduct with a minor, a felony of the third degree on November 5, 2010, and having previously been convicted of failure to register a change of address as a registered sex offender in Franklin County Common Police Court, case number 17 CR 3756 on August 14, 2017, and having previously been convicted of failure to register a change of address as a registered sex offender in Franklin County Common Police Court, case number 19 CR 976 on March 28, 2019. Violation of section 2950.05 F1 of the Ohio Revised Code. So that's the third degree felony charge. Now, do you understand what it is you're charged with, what the state said you did, when or now they alleged you did?
Yes, sir.
Do you understand the possible penalties?
Yes, sir.
Now, have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, the possible defenses you might try to raise in trial, and the possible outcomes of a trial with your attorney?
Yes, sir.
And are you satisfied with his advice and confidence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Are you taking any prescription drugs?
Just ibuprofen.
Just what?
Ibuprofen.
Okay. But no,
Yeah.
that's just a Advil, I think, so nothing other than that.
No, just antibiotics.
Antibiotic, okay. That's not affecting your ability to understand what's going on or anything like that?
No, sir.
All right, good. Has anyone threatened you to make you plead guilty here today?
No, sir.
Now, on page 2, there's 2 lines that are printed, bold, and underlined. I'll hold those up to the camera as well. You see that there on the camera? All right. Now, I'm going to read that. It says, defendant will enter plead guilty to the indictment as amended to a stipulated first offense. State defense jointly recommend 18 months incarceration. Is that your understanding of the agreement?
Yes, sir.
Okay, counsel, what does that do to the F3?
So the way it's charged right now, Your Honor, due to the prior convictions, it's mandatory that he be sentenced to 3 years incarceration. There's no discretion. If you remove the prior convictions, it's just a standard F3 9 to 36.
All right. Okay. Well, I was thinking that's what it was, and I want to make sure. All right. So the amendment is just deleting the prior convictions in Franklin County, making it a regular F3.
That's correct, sir.
Okay. You agree with that, Mr. Wagner?
I do, Your Honor.
Okay. So that means that I know that it's not a mandatory 36-month sentence as charged, but would be could be 36 months, but it's not mandatory. You understand that, Mr. Parr?
Yes, sir.
All right. Other than that, has anyone promised you anything to get you plead guilty here today?
No, sir.
Now, Mr. Parr, under the law, the matter of sentence is reserved to the judge, not to the parties. So even though there's a joint recommendation that the court should sentence you to 18 months imprisonment if you plead guilty, I'm not required to follow that. So if you plead guilty, once I've heard all the information presented, if I think that's not the correct sentence, I could impose any sentence between 9 and 36 months in the increments provided by law. You understand that?
Yes, sir.
Now, do you hold any license or certification from any state agency or board for any kind of an occupation or profession?
Certified carpenter, OSHA approved and licensed barber.
Licensed barber? Okay.
Yes, sir.
Well, that's a state agency. The other two, I believe, are trade certifications. And I know OSHA's not, I think that's federal. So, so we'll have to, under the law, the court has to have the clerk send a copy of your conviction entry if you were convicted to the state barber board so that they were aware of it. And then it's up to them whether they want to do anything with that or not. The court doesn't ask them to, but I'm required to have the clerk notify them so they're aware of your conviction. So it could result in some action against your license. You understand that?
Yes, sir.
Okay. Now, you have certain constitutional rights you must understand before you accept a plea as proposed. First, you have the right to counsel. Mr. Wagner has been appointed to represent you, not sent to work the case out, but provide any defense that could be available to you under the law that's wishing to provide. So if you decide you don't want to do this, then then he will still represent you, he will defend you, and that will include going to trial if that's what you want. You understand that?
Yes, sir.
Right now, in the Constitution, you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens that are selected for jury duty on your trial date. Once they are selected, the evidence will be presented, and they'd be instructed on the law by the judge, and then that jury would have to decide by unanimous verdict, meaning all 12 would have to agree whether the state proved your guilt. Now, if you decided you didn't want to have a jury trial, but you did not want to plead guilty, you can waive in writing, which means you give up the right to have a jury trial, and in that case, you would have what's called a court bench trial. That means it would be the judge who would hear the evidence instead of the jury. The judge would apply the law. The judge would decide whether or not the state proved your guilt or proved beyond any that. You understand that?
Yes, sir.
Right now, under the Constitution, you have a right to confront witnesses against you and cross-examine. What that means is that the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else is present. After they're done testifying, your attorney could ask questions. That's what cross-examination is, and that's for the purpose of trying to bring out evidence that might help your side of the case. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to use the power of this court to compel or force witnesses to come to court and testify for you, just like the state. So if you decide you do not want to testify, or you do not know if your witnesses will come in voluntarily or not, then you can ask the court to issue a court order, which is a subpoena. Of course, then, the court will be able to testify for you, just like the state's witnesses, even if they didn't want to be. You understand that?
Yes, sir.
Under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can, the judge can. You decide. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person. No one's even allowed to comment about it except in one situation. That is, if there is a jury trial and you elect not to testify, the fact that you did not testify cannot be used against you in any way by any person, and the court will instruct the jury, if you do not testify, to that effect, that they cannot consider it for any purpose. Do you understand that?
Yes, sir.
With the Constitution, Mr. Carr, you have a presumption of innocence, which means that it's burden proof is on you to try to prove you're not guilty simply because you're accused of this crime by being indicted. In fact, under the law, you don't have to present any evidence in your defense at all at trial. You can, but you're not required to. But whether you do or not, the burden of proof will remain upon the state of Ohio to prove your guilt on every essential element of the defense charge by proof beyond reasonable doubt, which is the highest burden of proof that we know in the law. Do you understand that?
Yes, sir.
All right, now originally you pled not guilty, Mr. Carr. That plea denied the allegation in the indictment, denied you committed any crime, and exercised all the rights I just described. If you change your plea from not guilty to guilty, that is the opposite. The plea of guilty admits the allegations in the indictment, admits the third crime, that you committed that crime. And that plea waives gives up all of the rights that I just described for you here today, except the right to have an attorney. You always have a right to have an attorney no matter what you plead, but with that exception. Your plea of guilty waives gives up your right to have a jury or a court trial. It waives gives up your right to confront witnesses against you and to cross-examine them through your attorney. It waives gives up your right to use the power of the court to compel or force witnesses to come into court and testify for you, just like the state. It waives gives up your privilege against self-incrimination, because if you say you're guilty, that's what you find you guilty. And it waives gives up your presumption of innocence, because if you say you're guilty, then the state's not required to prove that you're guilty. It also subjects you to being sentenced illegally by the court, which is what's likely to happen. And finally, it waives gives up any right to file an appeal that you think you could have had up to this point in the case. Now, if you are sentenced to the maximum sentence, or under other certain limited circumstances, an appeal can be filed. Any appeal will have to be filed within 30 days of your sentencing entry being filed. You understand all of that?
Yes, Your Honor.
And are you a U.S. citizen, Mr. Parr?
Yes, sir.
Right, do you have any questions about the charge and possible penalties?
No, sir.
You understand them?
Yes, sir.
Do you have any questions about the plea agreement?
No, sir.
You understand it?
Yes, sir.
You understand that the court's not bound by the recommendation?
Yes, sir.
Do you have any questions about the constitutional rights I've explained?
No, sir.
You understand those?
Yes, sir.
Do you have any questions about the plea of guilty, what it means, what the consequences of that plea if you enter that plea here this morning?
No, sir.
You understand that?
Yes, sir.
Now, is there anything you'd like to speak to your attorney about before we go any further?
No, sir.
Do you have any questions about anything that I've explained to you this morning?
No, sir.
Then is it your decision to withdraw your not guilty plea and plead guilty to the amended charge that deletes the previous convictions pursuant to the plea agreement that I've just gone over with?
Yes, sir.
All right, then, as amended, the charge and indictment will read, beginning on or about January 21, 2021, continuing thereafter in Highland County, Ohio, you did meet a registered sex offender convicted out of Union County Common Police Court in case number 2010-CR-0114, according to requirements of the law after 2008, having a duty to register a change of address, failed to provide notice of any change of address within 20 days of a written notice and was reckless in that regard, having previously been convicted of unlawful sexual conduct with minor felony third degree on November 5, 2010, in violation of section 2950.05F1 of the Ohio Revised Code, charge of failure to register a change of address as a registered sex offender, a third degree felony, bearing a possible prison term between 9 and 36 months in increments provided by law, and a fine of up to $10,000. How do you plead?
Guilty.
All right, the court finds that on this day in open court, defendant was advised of all his constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to criminal 11. Please accept it in order 5. Defendant is found guilty of the amended charge, as set forth in the indictment, with the amendment being the deletion of previous offenses, convictions, I should say, out of Franklin County. Court will go ahead and proceed with sentencing forthwith. Bond will not be continued, and defendant is found guilty of the offense. All right. I don't know if I asked you, but you are a U.S. citizen.
Yes, sir.
Okay. All right. Anything from the state regarding sentence?
Only was contained in the plea agreement, Your Honor.
Okay. Mr. Wagner, on behalf of your client.
Add two.
Your Honor, only that I asked the court to follow the recommendation. I know taking responsibility for one's actions is always something the court does look at. This would have been done a long time ago, Your Honor. If not for one, I was on vacation for about a week. Todd was in lockdown. From the moment I met him, he took full responsibility, did not make excuses. So again, Your Honor, we would ask the court to follow the recommendation.
All right, Mr. Carr, anything you'd like to say?
No, Your Honor.
All right, as a judge of the court that you be and are hereby sentenced to the correctional reception facility in Orem, Ohio, for a period of 18 months. Will be given credit for the sheriff of 56 days, originally arrested on July 29, correct?
Yes, sir.
All right, so 56 days, jail time credit. Now, upon completion of that sentence, Mr. Carr, it is possible that the adult parole board will choose which one post-release control supervision for up to 3 years. They don't have to, but it's up to them. If they do, you'll be supervised on the terms they set, and if during that period of time they determine that you have not complied with those conditions, and they can return you to prison to serve an additional period beyond that already served under the sentence of the court. In this case, 9 months for one or more violations. It's the cap for all violations, but that's could be up to 9 months for one violation, but no more than that for all. However, if you commit a new felony while under post-release control, then in addition, whenever sentence is judged in the new case to impose upon you, that judge will also sentence you for committing that offense while under post-release control. In this case, to an additional period of 1 year, or whatever time would be left on the period of post-release control, whichever is greater. If that occurred, that would have to be served consecutively to sentence in the new case. You're also ordered to pay the court costs, which doesn't grant execution order. If you fail to do that, the court could order you to do community service once you get out of prison, not while you're in prison, once you get out of prison. And that would be done in this county. You would be given credit for each hour you work in an hourly rate set by the court. And each hour you work will reduce your judgment by that amount until the day full. All right, is there anything further, counsel?
No, Your Honor.
All right,
No, sir, Adam, I'll stop. Apologize, Your Honor.
go ahead.
No, Adam, I'll stop over so I can plead for him.
Okay, that's right.
Yeah, thank you. All right, then you're remanded to custody then, Mr. Barr, thank you.
Thank you.
All right, I believe we have Ms. Redmond then next.
Yes, hold on just 1 second. He said, I'm sending him to you.
did the swamps.
Okay, are you Lisa, L. Redmond?
Yes, I am.
All right, this is case number 21CR119, State Line versus Lisa L. Redmond. This hearing is being conducted by video Zoom technology due to the COVID-19 concerns that are going on right now in the county. Ms. Redmond was indicted for receiving stolen property for felony. Her attorney is Jacob Wagner. He's appearing by Zoom. And also Mr. King on behalf of the state, assistant prosecuting attorney by Zoom. And also Mr. Arjima from the probation department. The reason that you're before the court, Ms. Redmond, is that I had a communication from the forensic center that we ordered an evaluation to be done of you, that they have not been able to get in touch with you, and spoke to a relative who said that you were not getting mail at your mailing address, and that you did not have a phone that didn't be reached, and so they were unable to proceed. So under the law, when that happens, the court is authorized to issue a warrant for someone to be taken into custody and be held until the evaluation be complete. So that's why I did that. Also, I'll note that I also received a fax from Mr. Arjima indicating that you would not comply with the court's order regarding your bail, OR bond, which orders you to report to them immediately and then once a week for 4 weeks. And it indicates that you had failed to report or have any contact with them since August 26th. And that is a violation of the court's bail order. Ms. Redmond, where are you living now?
It's kind of up in the air. I'm trying to get to my family in Wilmington and my man in Wilmington. This parent. And my home out there, I rented it for 25 years. And the landlord, Daniel Newberg, I just seen him. He hadn't been there over a year. There's been a lot of stuff ran under that property that was probably not healthy, that I don't know about, that he didn't.
Well, wait a minute, Ms. Redmond, I didn't ask for your life story. I just want to know where you were living. You say it's up in the air. That's my answer. I understand that. All right. Well, here's the order of the court. You're going to be ordered to be held in jail until the evaluation by the forensic center is completed. We will notify them today that you're in custody, and they will probably come there to see you. Ma'am, don't speak. You're in court of law just the same as if you were sitting at the desk in front of me here. And if you interrupt me, I can hold you in contempt. So you then conduct yourself with respect and you listen to what I have to say, and then I'll ask you if you have any questions when I get done. Now, so the order of the court is you're to be held pursuant to statute until you can be evaluated by the forensic center. They will notify them this afternoon. They should be up within the next week or 10 days. If they can't make it up, then they'll notify the court, and I'll have the sheriff drive you down to them and down to Hamilton. And that's going to be a psychologist who's going to talk to you and give me a report on your mental state as to your current mental state on the proceedings, as well as whether there was any issue at the time of the alleged offense. And that is in your best interest to cooperate with them fully. And they will then give us a report. Now, once evaluation is completed, I'm going to order you to be released under the same conditions under oath recognizance, which is your promise to appear. But again, remember, if you don't appear, then you could be charged with another felony. Now, your next appearance is set for October 20 at 2:15, and a jury trial set for November 17th. We will have to have another hearing after I receive the report. They have 30 days to get the report back to me, but I will release you as soon as they see you, unless they think they need a second session. No, normally they don't. So that's what's being done, and that's the reason why. Now, do you have any questions, Ms. Redmond?
Yes, the alleged crime never happened.
No, I didn't ask you about that. I asked you if you had any questions. You could talk to your attorney about your defense, but if you have any questions about what I just said.
Mental evaluation. It was hard enough to get it right because I purchased a vehicle And,
All right, well, I asked if you had any questions, not excuses.
yeah, I would like to be released, but I gotta worry about my family.
Okay, well, as soon as they can get out there and see you, they will.
I don't understand that.
Ma'am, don't interrupt me again, don't interrupt me again, or you'll be spending longer in jail on contempt.
Well, I'm having medical issues with my heart and my ears.
All right, Ms. Redmond, that's enough, all right? You can
That's
talk to your
the truth.
attorney about your situation. I'm
Well, I
waiting
got
for
to
you.
talk to my attorney.
Do not interrupt me again, or you're gonna be spending 10 days in jail. Keep your mouth shut. That means do not speak. And I'm gonna ask you to speak again. As soon as you are evaluated, you'll be released. You report to probation department immediately the same day. All right, that's the order of the court. Thank you.
That motion on, Miss Adams will be here by lunch.
Okay, thank you. Oh, man, I knew that was gonna be hard.
Yeah, she come prancing in that room. I thought, here we go.